I want to talk a little bit about the notice of proposed rulemaking by the ATF dealing with this definition of what it means to be engaged in the business as a dealer in firearms. This is a hot topic. We're not going to cover all the issues in this particular video. I'll do that later. But for now, I want to flag a couple specific things that stand out to me as, let's just say, untoward when it comes to the ATF's, yet again, overreach when it comes to our right to keep and bear arms. Stay tuned. We're going to break it down when we get back. Hey folks, I'm Mark Smith, host of the 4Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and a two-time nominee for a Gunny Award this year in 2024 for Top Voices of the Second Amendment, and also nomination for Most Influential Male in the Second Amendment. Both great categories, and I'm proud to be nominated by the Gundys, and I hope I earn the honor of that nomination, of both of those nominations. I was nominated last year for Breakout Creator of the Year and Top Voices of the Second Amendment. It didn't work out for me in the end, but that's okay. It's not about winning. It's about protecting our freedom. All right, folks, so here's the story. The ATF right now, as you know, has proposed rules about trying to expand the definition of dealer to force more and more people to become FFLs in order to engage in various firearms-related transactions. And that's not it. I think part of it also is that the ATF is very much interested in creating confusion and ambiguity so that people are not sure whether or not they are dealers, and if they get it wrong, they get to go to prison by virtue of engaging in the business of firearms without a license, when the ATF can come back and say that you had to get a license and now we're going to try to put you in prison and bankrupt you, whether you win or lose that criminal case. So with all those games being played, there's a couple things I wanted to flag about this proposed rule. Again, this ATF proposed rule is about redefining what it means to be quote unquote engaged in the business as a dealer in firearms. This is obviously, I'll put a link to the Federal Register number and so on so you can check it out. But there's a couple things I wanted to flag for you. The first thing that's kind of interesting here is that this observation or this attempt by ATF at overreaching and trying to expand the scope of who constitutes a dealer seems to fly in the face of some critical language in the 1986 federal statute, the Firearms Owners Protection Act. Specifically, if you look at the Firearms Owner Protection Act, which was enacted in 1986 during the Reagan administration, one of the critical things that statute says was to make it clear that the scope of the Gun Control Act of 1968 and the ATF's authority relating thereto had to be interpreted narrowly. Specifically, one of the critical things that the Firearms Owners Protection Act said in 1986, which is still good law, of course, is that any additional legislation is required to reaffirm the intent of the Congress as expressed in Section 101 of the Gun Control Act of 1968, that it is not the purpose of this title to place any undue or unnecessary, hear what I just said, undue or unnecessary federal restrictions or burdens on law-abiding citizens with respect to the acquisition, possession, or use of firearms appropriate to the purpose of hunting, trap shooting, target shooting, personal protection, or any other lawful activity. And that this title is not intended to discourage or eliminate the private ownership or use of firearms by law-abiding citizens for lawful purposes. That's critical language that I think provides a backstop, a backdrop to all of what the ATF is trying to do when expanding their definition of what it means to be engaged in the business. The other thing that I want to flag your attention, again, we can break this down in more detail down the road if you guys are interested in this. The other interesting thing is that, and this is going to come up in the courts to the extent this gets litigated, there's a really weird tension going on here. And remember, I've told you that I think one of the things that the anti-gunners are doing is they're throwing everything they can against the wall, hoping something's going to stick. They used to be strategic back in the day, I would say 5 or 6 years ago. They had very strategic goals about how they would take away our right to keep and bear arms, but they've thrown a lot of that to the wind, and now they're just trying to do whatever they can, and maybe it will work, maybe it won't work. Only time will tell. I suspect it's not going to work because it hasn't really worked all that well for them so far. But again, they're putting a lot of barnacles on the system, especially in those blue states, that they have complete control over the legislature and the governorship, as well as the courts. So with that said, there's this weird tension that's going on that I'm not sure anyone else has really noticed. That is, on the one hand, we all know about the ATF's quote-unquote zero tolerance policy. Zero tolerance policy when it comes to FFLs. We know that an FFL is a federal federal firearms licensee. You have to get an FFL to engage in certain business related to firearms. And what's interesting, in 2021, President Biden, as part of his anti-gun agenda, tried to establish this notion of zero tolerance for gun dealers. Specifically, and I'll read you the key language, the proposal said that the ATF was going to establish zero tolerance for rogue gun dealers that willfully violate the law. Gun dealers across the country are regulated by federal law that is enforced by the ATF, and dealers that fail to comply with their obligations under the law create risks for all of us. This is what the Biden administration said. They go on to say that the Justice Department is announcing a new policy to underscore zero tolerance for willful violations of the law by federally licensed firearms dealers that put public safety at risk. And specifically, they go on to say that absent extraordinary circumstances that will need to be justified to the director, ATF will seek to revoke the licenses of dealers for the first time that they violate federal law by willfully doing a series of things. Okay, and they also remind everyone that the Gun Control Act is a criminal statute, which of course means that if you screw this up, not only can you lose your license if you're an FFL, you could potentially go to prison. So with that zero tolerance backdrop, what's very interesting about this is that the ATF seems to be talking out of both sides of their mouth. On the one hand, they want to cut back on the number of FFLs in the United States by saying, oh, we have too many gun dealers and all this stuff, and we want to use our zero tolerance policy to cut back on the number of FFLs. So that's the one thing they're saying out of one side of their mouth. But now what are they saying out of the other side of their mouth? If you think about it, when it comes to this regulation dealing with engaged in business as a dealer of firearms, what they're saying is we want to expand the number. We want to expand the number of gun dealers in the United States. We want to expand the number of people that are FFLs in the United States because we want there to be more people. Now, we understand what's going on here. The reason why they want there to be more FFLs and gun dealers is because they can force those people to keep records of the guns that they buy and they sell in the bound book. And as a consequence, the government thinks that will make it easier for them to register the guns and take the guns away when the time comes. Maybe yes, maybe no. I don't know about that, but that is certainly the plan. But it is very interesting that you have this tension here. On the one hand, the Biden administration is saying we have too many FFLs, and therefore, among other things we're going to try to do to make it harder to be an FFL in America is we're going to endorse and embrace this zero tolerance policy to remove the number of FFLs that violate laws for any kind of picayune kind of thing. That's the one hand. But on the other hand, they're trying to expand the number of people that have to get their FFLs. So again, that sort of inherent tension is the sort of thing that I'm sure the Biden administration may not care about, but is definitely the sort of thing that courts, when they look at this, are going to say, well, this seems a little irrational. Your policy goes to some degree seem inconsistent in intention, Biden administration, which suggests that a lot of what you're doing is irrational and is driven by emotion and things other than logic, in addition to the fact that a lot of this is arguably violating the intent of the federal law, the federal statutory law given to all of us by Congress in the Firearms Owners Protection Act, which basically is saying that you're not supposed to be burdened in the law-abiding conduct of the acquisition and the use of firearms in this country. Now, to sum up this video, I also want to remind everyone there's two things coming down the road that could be a really big deal that touches fingers with this. One is, the Loper-Bright case. The Loper-Bright case in the U.S. Supreme Court this term specifically is deciding whether or not the Chevron doctrine will be destroyed, and it's entirely expressly once and for all. It's in many respects already done so, but now they want to clean it up, I think, and I think that is going to be what's going to happen here. And we also know the bump stock ban from the Trump administration, unfortunate, but nevertheless, this is where we are in the Cargill versus Garland case. That is before the U.S. Supreme Court, and this is going to be another example where the Supreme Court is going to really start laying down the rules of the road for the ATF, and this is the beginning of it. And I think that the ripple effect from the Loper-Bright case coupled with the bump stock case is going to have very favorable outcomes for the Second Amendment community and very unfavorable outcomes for the ATF. And keep in mind, the other thing that's going to, this is my best guess, is going to rise from the ashes again is the rule of lenity. The rule of lenity. Now, the rule of lenity lenity, which is an administrative procedural concept, says essentially that is there any ambiguity in regulations or any law, really, any rule of ambiguity as to what a law means, you rule against the government in favor of the individual, in favor of the citizen, in favor of freedom. And you do that because in the context of the rule of lenity, these involve anything where there's a potential for criminal persecution or prosecution. If there's a possibility of criminal prosecution that you can go to jail, then the rule of lenity is supposed to apply. Now, what's been going on over the last many years is that the ATF and the Department of Justice are trying to play games to pretend the rule of lenity is not the law of the land. They've been trying to rely on the Chevron doctrine and reliance and deference to these administrative agencies. Some people might refer to them as the deep state. I'll leave that up to you as to how you characterize it. But that sort of deference or deference, if you will, to the government, I think is going to be no more given the current composition of this Supreme Court and what they're about to do to the Chevron doctrine in Loper Bright and what they're about to do to the bump stock ban, which of course is really a technique and not an object, but we don't need to get into that right here. We will see what the Supreme Court does in that case, but either way, it's going to be, I think, a dramatic cutback on ATF authority, which is good for all freedom-loving Americans, especially those in the Second Amendment community. So, all right, folks, hope you learned a little bit something here today at the Four Boxes Diner. Make sure you subscribe, like, and share this video. Don't forget to follow me on X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.